there have to be ways of closing that door. Every administration that comes in, Democratic or Republican, has said something like the revolving door will be closed, but it never quite happens. And I think that's a huge problem, because if you have a permanent class of professional administrators who see their role as service to the public, now we can disagree about various things. Some of them might be progressives, conservatives, whatever, but they have this kind of, my job is this. This is what I do. I uphold, the public good, and I have to have, in some ways, a kind of not adversarial, but at least a sort of probing, critical relationship with industry. That's one thing. But if you have, Congressman so and so then goes to K Street, becomes a lobbyist for this and that, and then another administration comes in and he's, at the EPA or at whatever agency, I think that's a real problem. And so I agree with you with the problem of regulatory capture. But I think it's a matter of fixes, and I think the case can be made too strongly, and then what you're left with is just enormous concentrations of private power against whom we don't have any defense or appeal.
Hello, Culminators. I am very pleased to welcome back to the program for his first video appearance. Sohrab Ahmari was one of my first guests, and that was back before we decided that the audience, such as it is, could tolerate looking at me as well as listening to me. And we've been flying ever since. Sohrab has a lot to update us on, because it has been a couple of years. He's a very, very busy guy, and there's a lot to be busy with. If you are a public intellectual, and there are not so many of those around anymore, but Sohrab is one of them, there's a lot to intellectualize about, a lot to think about, and hopefully maybe to help the public, the world, come to some solutions. So welcome back to the show, Sohrab. How are you?
Thank you, Ron. I'm well. Hope you're well too.
Pretty good, thank you. Yes. So last time we spoke, you had actually, it was, I think, fairly soon after your previous book had come out, which was the sort of the education of Sohrab Ahmari. How you got to be who you are today. You were becoming an American, and we're past all that. Origin story is behind us. This is not like Hollywood, where they do the origin story after the adventure. We got the origin story. Now we can start the adventure, at least in terms of books. But you've had some adventures, right? Since we last left, I think you've made a couple of moves, or at least one significant move, in addition to a new book, which obviously we'll talk about in a couple minutes.
Yeah, so last we spoke was 2021. It was in the depths of the pandemic. And Zoom was something relatively new, at least for me, maybe for you as well. And now it's kind of part of the norm of life. And yeah, so I was working at the time as the op-ed editor of the New York Post, and I was coming up on a decade with News Corp, did the Murdoch empire. I had been at the Wall Street Journal before that for 5 years, and then doing the New York Post. And it was in the kind of aftermath of the censorship saga. You remember the Hunter Biden stuff.
Sure.
So since then, I left the Post in late 2021, and in 2022, in March 2022, launched a magazine called Compact. It's an online-only subscription-based magazine. The kind of ideological space it tries to fill is to bring together both conservative and, interestingly, left of center critics of our current political economic arrangements. And so we publish, people like Christopher Caldwell and Michael Anton, who are very much recognized, are associated with like Claremont and are definitely very right of center. But we also publish, Slavoj Žižek, the Slovenian Marxist philosopher, or Ben Burgess, who's a columnist with Jacobin. And the idea, the name tries to capture that compact as in an alliance or a kind of a covenant, but not quite a religious covenant, much more of a narrow, where can we see eye to eye in a shared critique? Is it possible to build a new center um, compared to the current center? The people who call themselves today centrists um, propose the most extreme stuff, right? Like war in Ukraine, nuclear confrontation with Russia. All this stuff is normalized as being centrist, and what is opposed to that is treated either as like the fringes of the right and the left, when in fact we want to propose that it's the so-called center that in many ways has become really extreme and out of tune with what millions of ordinary people on both sides of the Atlantic think should be happening in our lives, in our common life together. So that's the idea. It's been a year and a half now almost, and we're growing. It's very much subscription based. Our proposition is there's a lot of Substacks. We ourselves read a lot of Substacks for sure.
I certainly subscribe to a lot of Substacks.
Exactly. But our proposition is, look, the Substack world is like creating this heterodox environment, in part because the traditional outlets have become so doctrinaire and orthodox that even a lot of liberals find themselves kind of exiled. So there's a lot of interest in independent voices, but our proposition is not every thought that pops into XYZ writer's head is a good thought. Maybe it's a promising one, but it still requires the old school editorial kind of journalistic guidelines to be polished into a proper essay. And that's why we went with the magazine format. It is a magazine. We publish 1 or 2 pieces daily, high production values. We're very proud of how it looks. And no, it's been a journey, but it's been weird to be, basically your own boss or whatever, or you're a small businessman, you could say. You have to make payroll. Things that I used to just be an employee. You just show up and
Well, not only that, you were the church part of church and state. You were the artist. You were that was the ink-stained wretches, I suppose, the people who had to make payroll. But you served a higher calling. Now you want to serve a high calling, but you also have to keep the lights on.
Exactly right. It's well put. Yes.
Thank you. It's interesting to me that you include Marxists or a Marxist that you mentioned. Mm-hmm. Whom you mentioned. I think my intellectual son has mentioned him to me. There's something that we all had to learn from Marxism the hard way, and I suppose that your new book probably acknowledges or addresses that to some extent. Ironically, the left didn't learn it, mm-hmm. or if they learned it, or if they ever meant it at all, which is an interesting question. Tyranny Inc. This is a subject that I've had the opportunity to discuss, broadly speaking, and I have not had the opportunity to read the book myself, and that's on me. But you'll give me every reason in the world to order it as soon as we click off. It's really the end of the the libertarian pipe dream, mm-hmm. that if it's not a government, which they seem to describe as something that has a seat at the UN or a flag, but if it's not a nation state, it's private and it's cool and it can't do us any harm. And if you don't like it, build your own. I guess we're past that now.
Well, I think a lot of people are, especially on the right, where these sorts of views used to prevail, including, frankly, where I used to work at the Wall Street Journal editorial page. And now I think that's come under sustained pushback from the right. And I think that's healthy. It's come primarily as a result of these like big cultural or political flashpoints. So for example, I mentioned the Hunter Biden story. This was, outright censorship. It was censorship about a story that turned out to be true. And it was a story that implicated one of the 2 major party candidates in a very important national election, yet it was suppressed. And it was suppressed by this combination of governmental sort of urging, we now know, but largely the people pushing the button were private actors against whom a sort of libertarian would say we shouldn't have any political or legal defense, right? Because we choose to, click I agree to the terms of service, and no one points a gun at our heads to do that. And therefore, if a large company, censors your viewpoints on Facebook or Twitter, so be it. It's not government doing it. That used to be the prevailing view. And I remember a lot of conservatives, myself sometimes would say, well, government is terrible, but we can't do anything about that. It's a free marketplace. I think that we've all been a bit disillusioned from that, and I think that's healthy. I mean, another example is, I think, the predations of what's called woke capital or woke human resources, where ordinary people, as a condition of earning their paychecks, have to be subject themselves to ideological re-education. What I try to focus on in the book, I do mention examples like that in the opening, but for the most part, I focus on the much more kind of humdrum and invisible forms of private sector tyranny, in the workplace, in the bankruptcy process, in the arbitration chamber, in situations where, again, we are told that coercion is only what government does. When in fact, our lives in the marketplace and workplace are suffused with coercion, except it's not centralized, it's not top down. But given the fact that, in most industries, there's really only 2 or 3 dominant firms. We primarily, live under a condition of oligopoly and have since the late 19th century. The idea that you can free yourself from coercion, you're always free to find a better deal elsewhere, you're always free to, get another job, get another is not actually realistic in terms of how most ordinary people live.
And so the Marxians were right about that, weren't they? It just that's now our ox that's being gored, and we are acknowledging it.
I mean, I think, you in the 19th century, you could turn to a lot of people who sounded a lot like Marx. So if you, for example, look at speeches or writings by the Jacksonians, including President Jackson himself, or someone like Chief Justice Taney, or a little bit before that, even, you go to the sort of era of Jeffersonian democracy, there was this recognition that as industrialization takes place, the old kind of model of, a marketplace in which is populated by, numerous small producers, kind of yeoman farmers, artisans, and so forth, who are free to meet each other as sort of relative equals and at an arm's length and transact together and then walk away. That was no longer the case by the mid-19th century. And just the fact of industrialization, the barriers to entry that were created by economies of scale, et cetera, made it so that the vast majority of people had to toil for a living, for wages, and a relatively narrow portion of society, we could call the asset rich, controlled most productive and financial assets. Now, Marx recognized that and described that in some of the most sort of memorable language in the 19th century. But I think it's a mistake to just call this recognition that, hey, social class and power dynamics related to economic power are a reality. It's a mistake to make that just a Marxist idea, because in many ways, this recognition was in the American tradition as well. It's just that in the American tradition, we came up with other solutions to the problem, which I think are better ones than socialism, right? Like the full-on government ownership of everything didn't work, and we learned that in the 20th century. I think, so what I argue in the book is, yes, I mean, there are these, and I go through and I give a sort of a tour of our economy, of how it looks like from the point of view of people at the bottom. So just to give one example you may be familiar with, because I know you're a lawyer, the United States has long had, since the early 20th century, this idea of arbitration as a means for merchants of relatively equal bargaining power to come to terms. And in 1925, Congress enacted the Federal Arbitration Act, which is actually a kind of procedural rule that tells federal courts that you should uphold arbitral agreements between parties. But the idea was,
let me just clarify for listeners. Arbitral agreements, in other words, if instead of going to court, the parties agree that this relationship will be governed by mandatory arbitration, so that if there's a dispute, we will go to a private litigation rather than government litigation, and that's going to have certain advantages as we perceive them when we enter into the contract.
And for merchants of relatively equal bargaining power, it has many advantages. It has speed, informality. Often the arbitrator can oversee many different topics as opposed to federal courts that can have these kind of narrow topic jurisdictions, et cetera. It's good for those, but the idea was never, in the legislative history of the Federal Arbitration Act, was never that, in a workplace condition where there's these vast disparities in bargaining power between the two parties, arbitration would be enforced there. Yet, beginning in the 1960s, but especially after the 1980s, the Supreme Court gradually expanded the scope of arbitration to the point where, I tell the story of a guy named Stephen Morris, who was working for Ernst & Young as a low-level, non-licensed staffer, doing sort of very basic work. But during tax season, Ernst & Young, the accounting giant, extracts a lot of work out of its employees. In fact, it tells them that you should expect to work 50, 60 hours a week during this time. But it wouldn't pay someone like him, who was a low-level staffer, overtime under the Fair Labor Standards Act, which is a New Deal law that guarantees you overtime, and under the California labor law.
They were deeming him what they call an exempt employee.
Correct. Even though, he was a low-level staffer who was overseen by, more senior partners and so forth. So he sues, and Ernst & Young insists that he should follow the arbitration process. And in the course of the litigation that follows, because he doesn't want to be pushed into arbitration, by the way, not even class arbitration, it has to be individual arbitration. So you can't share discovery with similarly situated plaintiffs. You can't band together in any way. And it's plainly irrational. It would have cost Morris.
That's if you can get discovery.
Correct. Which is not, and the process of arbitration is much more of a black box. And Morris, in the course of this litigation over whether or not he should be forced to do individual arbitration, there was a affidavit which Ernst & Young didn't challenge that it would have cost them $200,000 to prevail ultimately in arbitration. But and this is in the sort of record of this case where the various federal courts accepted that, whereas it would have cost, he was trying to recover something like $4,000, $2,000 in wages and then $2,000 in damages. And yet our Supreme Court held that, the parties had freely agreed to arbitrate their disputes, and therefore that's the end of that. Now, bear in mind, the way it worked was he started working, there was no mandatory arbitration. And then down the road, the firm sent an email and said, if you show up to work the next day, you agree to arbitrate your disputes. The idea that you're free at that point to renegotiate is a complete sort of libertarian economic fantasy, but it's the kind of fantasy that appeals to a certain kind of libertarian judge. It's like, well, yes, at that point, as Milton Friedman said, that's not how it works. You want to show up because you have to pay the bills, right?
And that's a very common way that employment agreements and policies are amended during the period of employment.
Right.
That, there are different ways to do it, but it's at will employment, so you don't have to come in tomorrow if you don't like this. And that, again, we could see why. We could see the advantages of that, but all of a sudden you begin to get insight into why workers began to organize, because they needed some way to balance out this this complete lack of symmetry in bargaining power.
Right. And so, I compare this Canadian case where it was an Uber driver making $2,000 a month, and for Uber Eats, his name is Heller, and Heller and all the other drivers in the area, this is in Toronto, receive a notice that takes over their Uber delivery app and says you have to sort of click agree before you can proceed. Now, this is happening while in many cases they're in the middle of a delivery, and suddenly this takes over the app, and it's a several-page document. Everyone clicks agree. What it does is it reduces their wages drastically. Um, so Morris challenges this, and Uber insists on arbitration, which in this case would have taken place in Amsterdam, in the International Chamber of Commerce, where he would have had to pay 15,000 euros just for the case to be opened, in this foreign, forum, an ocean away. The Canadian Supreme Court in that case said, look, that's unconscionable. And so the two cases, it's, the Morris is the case in the United States. The comparable case is Heller, the Uber in Canada.
I'll tell you something else about arbitration that a lot of people don't realize. Even commercial arbitration, where there's relative, and relative is carrying a lot of weight here, but relatively equal bargaining power. Relative, it is to say that my 7 or 8 figure company has bargaining power with respect to Microsoft or something is a little bit preposterous also, but fine. It's not like being an Uber Eats driver. But what a lot of people don't appreciate is that one of the reasons that arbitration is not appealable as a general rule, 99 out of 100 times, is that the concept of arbitration in the 1930s was 3 arbitrators. I choose an arbitrator, you choose an arbitrator, and then you agree on a third arbitrator. Or a panel is, there are lots of ways to choose the panel, but the point is, I'm not being, my fate is not being decided by one person. Therefore, an appeal shouldn't be necessary. We're going to get it all done at once. That's cost prohibitive, except in the gaudiest of arbitrations, where money is essentially no object. So what you have is a system where there's no jury and there's no appealability and there's no review, and it is pretty lousy. It's pretty lousy. It's almost, and it's almost always used by parties that seek to discourage their counterparties from challenging a breach or challenging, any aspect of the contract, because it's just cost prohibitive. Okay.
No,
I'm sorry. Go ahead.
No. I mean, I just think that as bad as that is, in a kind of commercial context, what's outrageous about this, and so sometimes I become a right-wing critic of the conservative legal movement or the establishment GOP, is that this expansion of the FAA, the Federal Arbitration Act, and it has been radical. So, for example, gradually the Supreme Court said, oh, by the way, even if you have a RICO racketeering dispute, the arbitration element of the contract still stands. Even if everything else in the contract is fraudulent, the arbitration.
Even if there are parties that are not parties to the agreement with the arbitration, but they are, but one of the contracts involved is mandatory, does have mandatory arbitration, some or part of that entire dispute can
get shoehorned into arbitration. And so, but just in the employment context, it's really outrageous because, especially a lot of the judges and justices who gave us the current regime, claim to be originalists, which means they are the intentions of a framers of a law or a piece of statutory law should be supreme. So in this case, the people who were pushing for the Federal Arbitration Act, were involved with the New York Chamber of Commerce, but also, then Secretary of Treasury, Secretary of Commerce Herbert Hoover was a huge concern, right? He was a huge ally of the FAA, and he wrote lawmakers, Hoover. He said, look, we realize one of your concerns is, quote, the inclusion of workers' law contracts in the law's scheme, and rest assured we're going to make sure that doesn't happen. Or W.H.H. Piatt, who was an official with the American Bar Association, who was pressing for the law, he testified, that this is purely about giving merchants the right or the privilege of sitting down and agreeing with each other. Now, that's all there is in this. And when someone said, well, what if stronger parties, abusively take advantage of it against weaker parties? He said, I would not favor any kind of legislation that would permit the forcing of a man to sign that kind of a contract. I think that ought to be protested against, because it is the primary end of this contract that it is a contract between merchants, between commercial parties of relatively equal bargaining power. So this is all in the legislative history of the FAA. Sorry, we're going into the weeds, but I was just giving one example of the
It's my fault, because as a lawyer, you mentioned arbitration, and I'm thinking of the very, very mixed bag that arbitration presents. Yeah, but in that narrative, though, you come back to a point that I think is really one of the big libertarian stumbling blocks, which is this idea that corporations, which they conveniently tend to forget, are creations of the state. There's nothing in the natural law that makes a corporation exempt from personal liability, a stockholder of a corporation exempt from personal liability. And corporations are just like big people. They're the way people do things together. And just as people can, or merchants can deal with each other, a person dealing with a corporation is just two different people, both of whom, after all, have free speech rights. There are a lot of moving parts here. I mean, I think, like, you and I have no trouble understanding that libertarianism is a failure philosophically, not only politically. And one thing I want to talk about, believe it or not, as it happens with when you and I talk, time begins to evaporate. Where's the space for the spiritual on this? This economic analysis, this sort of bloodless, let's take a step back and reshuffle the deck. Is it possible to restore dignity and humanity, which I'm assuming are part of the program, that to the way we deal with each other economically and otherwise, in a world that is, or at least in a society that is so utterly lacking in an understanding of the spirit of the soul, where the religious tradition has been so severely undermined?
Yeah, I mean, so to be clear, my outrage about things like arbitration abuse in the workplace, or some of the other cases I show in the book, for example, the corrosion of the real economy by private equity, right? It didn't used to be that the American corporation was returning almost every bit of capital it had to shareholders. Why is that bad? Because you erode your capital enough and then you don't have a business. And that's often the model that's forced on companies by hedge funds and private equity, and so on and so forth. And in each case, I tell a kind of individual story of someone harmed by these processes. My outrage with this is inspired by my faith, the Catholic faith, where, for example, in the case of Morris and his wages, the unjustly withheld wages, in the Catholic tradition, withholding a worker's wage is one of the four sins that cry out to heaven for vengeance. That's how the Catechism puts it. And by the way, it's in the book of St. James, which is in the New Testament, but there's also analog commandments in the Hebrew Bible.
Yes, it's a very serious issue addressed in both the written law and the oral law, withholding a person's wage, an acknowledgement, presumably. I mean, we don't claim to know why God gives us the commandments, but an acknowledgement of the imbalance of power.
But exactly. So, but where I, part ways from a kind of purely spiritual politics. Oh, if only we could restore people's, moral sense. We'd have a better economy. I think we would. That would help, but it's not enough. And
right.
And all these traditions are recognize that mere exhortation to virtue is not sufficient to help form a more virtuous citizenry. You also need law with its capacity for coercion can bolster the work of spiritual uplift. And there are, in the 19th century, again, in American history, all these traditions that saw what was happening in the economy. Of course, what was happening in the South, the antebellum South, was slavery, and they mustered a religious response to it. But often they were most effective when that religious response was married to I don't think law reform. So
William Jennings Bryan would be probably the best example of someone who took evangelical fervor and tried at least to turn it into a political platform. He ran for president, what, 4 times?
he did. But he ended up as Wilson's Secretary of State. That was his reward. Yep. So the progressive farmers in the late 19th and 20th century. When we say progressive, it's not quite the
Right.
connotation that it has today. Like they weren't blue haired. you know.
Right. No,
Uh,
but I mean, the Sherman Act is, is the much forgotten Sherman Act, the much maligned antitrust laws were the fruit of the, were the fruit of the progressive movement in many, or were an important fruit of that movement, and they were considered to be ways to save capitalism from the threat of communism, from socialism.
right. Right. And so just to close the loop on like my book solutions section, as it were, I present a critique that a Marxist could read and say, hey, that's right, that does happen with unrestrained markets. But again, as I say, um, you know, a lot of Jacksonians would say the same thing. Lincoln would recognize some of the same problems with unhindered markets. Um, but my solution for it is the solutions that we forged in the 20th century, and especially in the decades immediately after World War II, which is not abandoning markets because they allocate goods and services and capital quite efficiently in many ways, but there has to be sort of some recognition of the fact that unhindered markets produce vast disparities of power that kind of make a mockery of democracy. We have political equality, but if you have that degree of inequality in wealth, then our claims to political democracy come under pressure. So, what was the solutions for us? It was, in some cases, antitrust. That was the sort of Sherman Antitrust Act and various Brandeisian solutions. New Dealers, by the way, a huge Catholic component to the New Deal, the Wagner Act, et cetera. So we don't necessarily can reproduce every element of that post-war mid-century consensus today. The macroeconomy has changed in important ways, but some of the principles, the principle of countervailing power, if you have one large concentration of power, you want in the market for the persons subjugated to that power on the other side of the market to be empowered. So what do I mean by that? Laissez-faire types or libertarians say it's enough to have competition between sellers or just between buyers. But countervailing power is the idea that there should be a kind of competition between sellers and buyers as well. So, for example, in a labor market where you have typically very few buyers of labor and many, many sellers of labor who are workers, you need to try to bolster the power, the countervailing power of sellers in that case. That would be wage earners. And in many other areas, this happens naturally. So when you have, for example, appliance manufacturers, typically department stores exert pressure, because of their power on the sellers or producers, and then they pass on the savings to consumers. Likewise, in other markets, like the labor market, you can do the same thing. But in some markets, it just needs government help, right? In order for countervailing power to emerge, you need laws that are able to do that, because otherwise what governs are the vast disparities in power and wealth between the two sides. And that's what the Wagner Act did. And I think that basic principle is applicable in our time.
So those of us who remember the 70s, stagflation, remember a time when these principles were prevalent. There was still a good amount of antitrust enforcement from the government. Unions had a tremendous amount of power over both government and major economic enterprises. There was a problem with growth. We began to reach a point, and some of that was complicated by the subsequent oil shocks in the early 70s. But what we saw was that government, and when government is given that kind of power to level a playing field, it will inevitably, as political science predicts, become captured by competing forces. And of course, a generation later, here we are now, where technology companies that basically run so much of the world that matters to us, or just the corporate world and the financial world and government and law enforcement, have become this block, this solitary block. It's sort of hard to understand how we can argue for more power being returned to regulators when regulators are essentially private actors that are being paid by us as taxpayers to make our lives more difficult. So how do we deal with that good faith problem, with that, the lack of aspiration and statesmanship? There's always been corruption, obviously. That's goes back to the very beginning of government. But if we think of the 50s and 60s as a kind of era of relatively good feel, when things kind of maybe worked better than they do now, how do we address that problem? Why can we trust government?
Yeah, I mean, I guess I don't have as much uh, anxiety about government power right now at this moment, because what I see as much more menacing is uh, private power. And the reason why I held those up on a balance, I hold them up at sort of in different ways or weigh them differently, is that I do think at the end of the day, there is one that has various public mechanisms for public and democratic challenge. The other doesn't. And that said, I mean, I think that people who are take my position do need to be very careful about regulatory capture, which it's no joke. I mean, I think that there are ways to sort of create bulwarks against that, which varies. By the way, politicians of both administrations or both parties have sought to do that. So, for example, revolving doors between Congress, administrative agencies, and corporations have to be,
and lobbying.
and lobbying. There have to be ways of closing that door. Every administration that comes in, Democratic or Republican, has said something like the revolving door will be closed, but it never quite happens. And I think that's a huge problem, because if you have a permanent class of professional administrators who see their role as service to the public. Now, we can disagree about various things. Some of them might be progressives, conservatives, whatever, but they have this kind of, my job is this is what I do. I uphold, the public good. And I have to have in some ways a kind of, not adversarial, but at least a sort of probing, critical relationship with industry. That's one thing. But if you have, Congressman so-and-so then goes to K Street, becomes a lobbyist for this and that, and then another administration comes in and he's, at the EPA or at whatever agency, I think that's a real problem. And so I agree with you with the problem of regulatory capture. But I think it's a matter of fixes, and I think the case can be made too strongly, and then what you're left with is just enormous concentrations of private power against whom we don't have any defense or appeal.
Well, let's go back to your, to sort of close everything here, come full circle. Your very compelling original example of where the technology media companies shut down discussion of the Hunter Biden laptop.
Mm-hmm.
They did it hand in glove with the government.
Mm-hmm.
In order to secure the election of one political party. No one would stop it. No one could stop it, except through sort of alternative media that still haven't reached the level of maturity that they're able to meaningfully, have a kind of really meaningful impact on most of the electorate. How would things look if that situation came in and the Sohrab Ahmari program have been adopted for 5 years, how would things be any different?
Yeah, so with terms of big tech, frankly, I turn to the great leftist thinker Clarence Thomas, who has who has mused about the necessity of perhaps treating these companies as common carriers. You know, your phone company can't discriminate against you for your your political views.
Unless you have over 5 million impressions, then you're special. We would agree with.
Exactly, exactly right. So, I mean, I think there are many big challenges ahead, but this is one of the ones because we cannot have political contestation if a handful of Silicon Valley oligarchs, and I include Elon in this, we should not be naive, can control discourse, whatever their ideology might be. You know, Elon tends this way, Zuck that way. Um, I think that our public square is these platforms. And I think that's the premise behind Justice Thomas's, sense of alarm and why he proposed this. It's a kind of dicta. It's in a dissent. It's not yet, a fully formed opinion. It just briefly says, but I think his sense of alarm, and it comes from that. We can't have political contestation if the public square is, privately owned and then privately kind of minutely controlled, and the rules are constantly changing, and the algorithm might end up, against you. And then how do you appeal to it? The chat bot will eventually turn you away, and there you are, you've been unpersoned. So I think that's one of the cases where, you can draw on common law resources. You can draw on a lot in the 19th century, where we began to think of what it means to have common carriers. So it's in the American tradition. It would be in anything radical, but it should be like a regulated utility is the bottom line.
I think the fly in the ointment is the cultural and moral terrorists. There's no platform that the extreme left and extreme right, or nihilists who don't fit anywhere on the spectrum, but who are they're interested in causing destruction, won't ruin. And the rules of the road that these platforms have inevitably enacted all started out having a very logical basis, which is that these Nazis would show up, or these Antifa would show up and terrorize people, and they would do so anonymously. So you say, okay, fine, we're going to have some bright lines. You can't do this, and then those lines keep creeping up and creeping up, and then you have the involvement of law enforcement. It's a very complicated matter, but I think you're right. This is one area that needs reform. How much government can or should do. Government, I think, has become has never been less trustworthy in American history. But governments, as I was snarkily saying in the beginning, aren't only things with flags and armies and national anthems. I'm always pointing out that, Google has a net worth far greater than many, or maybe even most, nation states in the world, and far more influence and power. And we have to adjust our political understanding and our economic understanding and social understanding to recognize that these are powers that the individual and the soul have to fight against, or at least be wary of, as much as any state.
Amen.
Sohrab, best of luck with Compact and with the book. I'm gonna let you know on Twitter when I've read it. And I want to set up a debate between you and Michael Malice.
Oh yeah, we have one coming up. At least it's scheduled.
Maybe that's what got it into my head, because you're both identifying the same problem, and your solutions could not be more different. So make sure that I want a personal invitation from you, because I want to make sure I don't do it on a damn Saturday.
No. It'll be it'd be Zoom. It wouldn't be in person.
Okay, yeah. I'm even prepared to moderate, or Cernovich got that gig or something. Yeah. Okay. So thanks so much for coming. It's great to see you again, and we'll talk again soon.
Thank you, Mr. Coleman.
Mr. You know, now that I'm 60, I let people call me Mr. Coleman.
No, no, I know. I sort of felt like I have to do that.